All right. We are live streaming today, just to give you a heads up on that. I believe, I don't know if it's actually working. All right, let's get started. Let me call the docket. We have some students here today. Great. Thank you all for being here. We have some students, attorneys who are sitting there with them. Please welcome them. Tell them a good story. They're here to learn about what we do. And I'll tell you what, on the very first day, the students came in and the things they said about the courts and about judges and about defense attorneys and about the state, they're not too happy with us right now. So please give them reason to see what we are doing here. We're running a professional organization. I tell them how hard y'all are fighting for your clients, how the state is doing the right thing. So please feel welcome to talk to them. Defendants, if I call your name, please stand just so that we can identify you. And attorneys, if you have a quick announcement, please do so. Tim Blunt.
President of the Council, Your Honor.
Thank you.
Would you like to have it now or later?
Well, we're on a plea. We'll come and approach, but I'll mark you as conferring.
Yes, sir.
Thank you. Josue Carranza Galdamez. He's in custody. Jardin Coons. Do we have interpreters today? Do we have sign interpreters today? Have you heard of any, bailiff?
No.
Oh, they are here? Okay. Maybe they're outside. Timothy Enholt. Thank you, sir. Ariety Flores Velasquez. Devin Gallegos. Manuel Granados.
He's in custody, Your Honor, and I don't know if we're right on the obtaining his criminal records.
Okay, I'll mark y'all conferring. Thank you for being here. Carl Heights. Julian Hernandez.
President of Council, Your Honor, we're going to ask for another pretrial. There's a couple of videos we've requested that weren't included in the original discovery packet. We're waiting to get.
Okay, let's approach on that one first, then we can get you out of here. Right after we call the docket, and just I'm going to make notes on that and ask the state when they can get you that information. Thank you both. Mark Herrera.
I just submitted a waiver of arraignment on that.
Very good, thank you. I will sign it. Do we have it? Okay, we'll get it signed for you. Is Mr. Herrera here?
No, Judge, but I figured with the waiver.
Okay, that's fine. I was just going to let him know the status. After you get the reset from Becky, feel free to let him know. William Love.
I'm President Judge in custody, recall.
Okay, very good. Mark y'all conferring. Thank you. David Luna. John Marmolejo. Cameron Marshall.
President of Council, Your Honor, spoken to state, we'll be asking for a recess today.
Okay. Y'all can approach after Mr. McNabb. Terrence McAfee. He's in custody. Rashid Melton. He's in custody. Stephen Merca. Did we end up getting someone?
No, we need to have the other withdrawals.
Okay.
Do you want to appoint someone today?
What's that?
Do you want to appoint someone today?
Yes. Can we please get Merca up here first? Thank you. Joseph Middleton. Thank you, sir. Philip Moreno. Thank you, Mr. Moreno. Both y'all just wait around for your attorneys, please. Sean Parker.
Sorry, he's in custody and we need to approach on that.
Very good. I'll mark you conferring, and when you're ready to bring him up, please let the bailiffs know so they can.
He's the one that's here.
Okay, yes. And are the interpreters with him downstairs?
He just stepped out for a minute. I saw him.
Okay,
If we have Mr. Granados brought up after Mr. Parker.
I'm sorry.
If we have Mr. Granados brought up after Mr. Parker.
Okay. So Parker first?
Yes.
Okay. Thank you, guys. Saul Plata Contreras.
Council, Your Honor. You can represent the test.
Very good. Thank you. Josiah Quintanilla. Very good. Whenever you want to approach, just let the bailiffs know so they can get him up. We have him in here. Thank you. Edward Resendez.
He's in custody, Judge.
Good timing. Swings open the door and very good. I'll mark you conferring. Juan Saldana. Gustavo Salceda.
He's in custody, we're conferring.
Very good. Thank you. Giovanna Solano Sequeira. Thank you. Ranulfo Torres Padron. He's in custody. Anthony Torres. In custody. Abel Valdez. Quincy Walker. Dustin West.
Judge, he's in custody. I believe we're gonna work that out this morning and I'll.
Okay, I'll mark you conferring. Thank you both. Joey Williams.
Yes,
Okay.
and she's in.
Did we sign off on it?
I'm not sure, I think it goes straight to Judge.
Lingji Wei.
In custody, Your Honor.
All right, we have an interpreter for you today.
Right.
And so let's make sure that we are moving now. And she just came on my screen. So we're ready for you all when you're ready. Just let us know because we have her here on the dime right now.
May I approach, Your Honor?
Let's do it after. Let me just finish this. And we'll put you right after McNabb and one other that was there. I'm sorry. And Jace Zeman.
Present Judge, he is in custody in the background.
Okay.
So.
Becky will give you the reset on that. Thank you. All right, that's all we have for the docket. You may confer. Mr. McNabb, let's get going. Good morning. How are you?
Good, great. Do we need Mr. Hernandez for this? This is just scheduled.
Yeah, I mean, I think so. It's a Hernandez.
Julian Hernandez.
Quiet, please.
Morning, sir. Thank you for being here on time.
I apologize.
No problem. All right, so there's an issue with some discovery. What's that about?
Just there's a couple of videos that don't have yet. One of them is a primary video, so we've been through several. It's just we're requesting the other two.
State, what's the status on getting those videos to defense?
Judge, once I know the names of the officers, I will get those videos either sent to defense or confirm that they do not exist.
Okay, can you confer and please let me know before you leave? I think you can go and I'll count on the state to let me know the status and when they can get those to you. Is that all right? Or
Understood. No, whatever. you
Okay.
think.
no, I'm gonna write a note in here. We
Certainly.
think we can get those to you by Friday or whatever day they think they can get them to you.
Understood.
Okay?
Thank you.
All right, so after you get your reset, you're free to go about your business. Thank you. Just let me know.
Yes, Judge.
Quiet, please.
Yes, yes, of course.
This is for Cameron Marshall.
Marshall. Is he here?
Yes, Your Honor.
Mr. Marshall, can you come forward, please?
Cameron?
Good morning, Mr. Marshall. How are you? Good. Thank you for being here on time. All right. We were back here in July and I have notes that the plan was to get mitigating evidence.
My understanding is that we are completing some records. My client is also working on some counseling and therapy for to be able to provide additional mitigation records. So we're asking for an additional reset so we could all the information.
Okay, Mr. Marshall, I think last time we were here, we discussed that this is on you. Your attorney is stating that can only provide to the state the mitigating information if you are timely getting it to him. So let's make sure that that's on you. that you were doing that. What we're going to do is the next setting now, this was a plea setting, the next setting is a trial setting, all right? That means, it does not mean that you have to go to the trial, but it puts an emphasis on the urgency of you getting the information through your attorney, you understand? And so that he needs plenty of time to get it and then be able to pass it off to the state so that they can make decisions based on that information. All right, so we will move to a plea setting on this. I mean, I'm sorry, we're on a plea setting, we're gonna move to a trial setting. So make sure we understand the urgency. I mean, if it's not something that you're that concerned about, there's really no urgency, okay? But if it is something that you want the state to consider, it's all on you. All right, you do that, understand? All right, thank you very much.
Appreciate it.
Yeah, just fine.
Good morning, Allison, how are
Good
you?
morning, Judge.
Did you have a good weekend?
It was pretty good.
Good.
It was pretty good. I did manage to catch the plague that's been going around the office, but I think I've recovered, so.
Did you,
one or the cough
The
one?
stomach one.
Oh, gosh. Cool.
you watching football?
I did. I watched a lot of football.
Who'd you see?
Let's see, we watched parts of the UT game. We watched OU because our OU friends were in town. We watched LSU and yelled a lot at the TV.
Who was that one? Who'd they have?
It was, God, who did they play? It was someone that they should not have struggled as much as they did against. And they came very close to losing it, and then they managed to save it at the last second. Who was it? I don't remember. Saturday feels like forever ago.
It does.
And then we watched a lot of, not a lot, but several of the NFL games on Sunday. So it was a lot of football.
No, football. Filled weekend.
Yes.
Well, good for you. That sounds relaxing. Unless your team's down to the last second like Georgia was.
You know, my fantasy team managed to pull it out. So that's the important thing.
That's right. This is what your main concern is, your fantasy team.
I have never cheered so hard for just a select few Kansas City players.
Who did you have?
Rice and Pacheco.
Yeah, you told me that, Pacheco. He led the game in rushing though, didn't he?
He did. He had a very good game. He was limping at the end, which I'm slightly concerned about, but we'll see. He's a tough guy.
Oh, we got 3 in here, all right. How are y'all doing over there? Good, good. I'm glad you're here. Will, both of y'all, tell them something interesting, please.
Will do, Judge.
Yeah,
Can it be about you?
it depends on what kind of interesting it is.
We'll finish our deep.
Now, these are students from Texas State who come over to see college and court, and we just want them to get an idea of what's going on in the courthouse. And so
We'd be glad to show them how not to do it. Your Honor.
that's not true at all. We appreciate y'all's work.
All right.
Thank you. Yes. Name? Granados. How you doing, Mr. Granados? Doing okay today? Okay. You've got a new pocket square today. That is a very precise folds you have there. Did you do it? All right, very good. And the G for, I'm assuming, Google? No, that's for your username. All right, what are we here to do today? We're here on another pretrial setting.
It was a status check, Your Honor, to see if the state was able to get the medical records from the well path at the jail. 2 seconds ago, state immediately went and requested those via subpoena, and I think the last time we were in court, this abuse was not sure that that been returned.
We have not received anything from them, Judge. I have my investigator following up, but I was out last week at the end of the week ill, and so I have not had a chance to follow up on that. But as far as I know, and as far as our records are showing, we have not received anything additional from them.
Okay, let's check on it and reset this for tomorrow. Okay, and if this is a situation where WellPath, I mean, we're looking at well over a month now since that request was going on,
Longer than that was anyhow.
and end of July,
Late, yes.
2 months potentially. And state, I know that you've properly requested it, and if they're holding out on getting that to you, we need to find out why that is. So let's just reset this for tomorrow, please, Becky. And what's that?
Savor his name.
Okay. So I'm back tomorrow. Mr. Granos, we'll come back tomorrow and get the answers to these questions. All right, thank you. I'm going to be interested to see what's in your pocket tomorrow. Have a good day. Say, let's try to find out what's.
I've asked Chris to reach out to them again and told him that you were considering a show cause or a writ.
I don't know that I said that, but let's.
I think if that gets conveyed, we may get a response a little bit quicker, so.
We just can't have this where someone who the county is paying a lot of money to
I agree.
is causing us more expenses by not timely providing information. All right, who do we want to do next?
Vicky was just appointed to Stephen Rosa.
Oh, great. All right, Mr. Merker, can you come on up? How you doing, Mr. Merker? All right. So I understand you've just been appointed, Ms. Brown. That's good. I have an excellent attorney here now. We've got to get moving on this case because of the age of it. So that's all I'm going to say for right now. I want you to have the opportunity to step back and talk to her. As I remember, we've already done a motion to suppress on this case, haven't we?
We did, but I really want to ask that we have a motion to rehear that actually.
I mean, I remember it, but the attorney did.
No, I mean, he did textbook well, but using Arizona versus Hicks on my case, I don't think was very relevant. I actually have a question ready.
Well, I'm gonna let y'all talk about
Let
this.
me, Judge,
Yes.
I'm gonna be here tomorrow on the other individual. May we reschedule Mr. Murphy tomorrow?
Yeah, that makes sense. That way she gives,
I've got time.
she just got appointed 15 seconds ago. That gives her time to look over it, but
He also has a new charge on the docket.
okay. We can.
He doesn't like to wait.
I mean, well, why don't y'all step back? Let me do another case and you can just talk about it.
Okay.
All right? Okay. I mean, I'm happy to do it. Let's just, I'm gonna take care of some, since we have all these others in custody. Hello, how are you? Thank you for being here today.
Yes, sir.
Ms. Parker?
Yes.
All right, I'm gonna step in the middle.
100%, but I didn't throw up on the way to work today, so that's improvement.
No, I didn't.
What are we doing on this second case here?
It's been indicted, Your Honor, and the state has given us a recommendation that is not consistent with granting deferred today.
Okay.
But the PSI, the department recommends TC and not probation. I do have a copy.
Have
I have not.
you had the opportunity to review the pre-sentence investigation report, discuss it with your client?
I have reviewed it. I have not, I've given it to Sean to review.
Why don't I just let you step back, answer any questions that you may have, so that you can answer that question on the record.
I guess my biggest question, and why I wanted to bring up early, is are you inclined to go along with the deal, or are you perhaps not, are you gonna reject it? Because that will lead to the proper discussions I have with him. He does have new offenses pending. Ally, they are burglary
Burglary of a building and engaging in organized criminal activity as a member of a criminal street gang with burglary of a building as the underlying offense.
I mean, I'm going to consider all arguments that you put before me on this. The new cases that he picked up, we knew about when the state made that offer. Is that correct?
I don't believe so,
I don't-
Judge.
think so. I think I want to say he pled, was out on bond.
He
as a
made
result of
the,
it.
the state made the offer, and I believe he accepted, at the time that he accepted, we knew about the new cases, but
They were-
it
They
wasn't
weren't staffed. You didn't have the reports yet.
correct.
So it's somewhat premature. We had to plea, we're in a plea setting or go to jury.
Okay.
And so it was kind of he had to make a decision. He was guilty of what he had done, so he pled. Yeah, so it's kind of,
Well, I think the discussions you have to have are what are the options coming before the
Correct.
court, to include that I might not accept the plea,
right,
given what's happened.
right.
And
I just wanted to know where you were leaning, so I could get that. Okay.
you've seen this court and you've been in
I know,
situations
but I
very
don't-
similar.
not like this.
And I bet that you,
Well,
if you consider that
This
I
is a
would
little
do,
weird.
I would try to be consistent with what I've always done, you have a pretty good idea of where we're going here.
All right. so
Okay.
We'll step back. Then. Thank
All
you.
right, thank you. Please,
Are they coming back up or no?
I believe they will. I need to do what is necessary on it. How you doing? Good, who are you here on?
Philip Moreno, and Mr. Moreno is present.
Mr. Moreno, can you
Quiet,
come on up,
please.
please? Thank you. Morning, sir. How are you doing? Good. Thank you for being here on time. All right, we're here on a pretrial setting today. Do you have an offer?
Yes, we just got an offer just now this morning, and
Do you have discovery?
yes, and we are working on mitigation, and he's gonna be getting me some stuff and some treatments that he's gone to, some classes and things of that nature. And we just asked for resetting, get that together, get a counter offer, hopefully.
No problem. We'll do another pretrial setting. Keep in mind that your attorney is relying on you to get that information to him. So make sure that you're taking the steps that you need to so that he can pass it over and the state can consider it. Because it's just on you now.
I thought it last time, I forgot it.
Okay, well, stay on it and, you know, maybe you may need to do a special trip when you're not in court because he can still get it to the state. All right?
By Dallas right now, so it takes 10 minutes to get here.
Okay.
Get the bus.
Well, maybe you can fax it or email it or take some pictures and send it.
Yes.
Okay? That way we're just continuing to move your case forward. All right? Thank you very much. Anything else we need to take up?
No, Mr. Moreno, no.
Very good. Thank you.
Thank you.
Let's do another reset. Thank you.
And one more judge, Coons, Jonathan Coons.
Yes.
Don't believe that he answered up this morning, but I can check back.
Yes.
Staff,
He did not answer.
Okay.
so that may impact his ability to answer.
But
The
I,
interpreter's looking for the-
was that?
The interpreter was looking.
Okay,
But I think they're out with Vicky and her client.
okay, well,
Email
there we go. All right,
Oh, okay.
They require their own interpreters.
Okay.
okay, sounds
So just
good.
keep an eye on it so that we can get them moving.
All right, perfect, thank you.
Come on forward. How are you? Good morning. Who are you on? Lata. I do my,
Yep, every time.
every time. See, but I'm knowing now. I'm so predictable.
It's a good joke, I like it.
Mr. Plata. Morning, sir. How are you? All right, what's our status here?
We are asking for a recess for the plea docket. It was our third pre-trial, second, third.
All right, and you have all discovery you need on this case?
Yes, sir.
You have an offer.
We do have.
Very good. All right, I would see, probably after this one more pretrial, then we'll be moving towards a plea setting and a trial setting. That's still, all of those are 190 to 120 days out. But just so that you understand that, you know, at this point, there's nothing keeping us from moving forward, and we should do so timely. So make sure if your attorney needs anything, you're providing it to them so that they can confer with the state. Understood? Any other questions?
We're getting reset to a pre-trial then?
Yeah, it's another pre-trial. All right, thank you very much. Have a good day. Thank you for being here. Thank you for being here on time, sir. Morning, how are you? Good. Who are you here on?
Case Judge Kurtzman, Devin Gallegos.
Gallegos, yes.
That order sending him 60 days. I'm still talking with the case and a couple of resolutions. I've met with them. We'll just doing the door time together.
Okay.
Just gonna have an idea of where it's at. That's what's missing.
So I guess he's gonna be there at least, is that right?
Yes, sir.
So we're ascending at 60 plus the next opportunity.
That's possible.
Okay.
I'm still speaking with the state.
Sure. Well, and yeah, I'm not saying anything about that, but just so that we have a timely setting, because when he comes back to Hayes County, we want to make sure that we're ready to go, and that there's you know, there could be a tight window there.
Yes.
Well, hopefully he's feeling well at that point. That's my hope, is that they've been successful with him. So we'll just get that. I don't think we need to come back in 30 days, do you? Or do you want? Okay. All right. Well, Becky, let's just get them after Mr. Gallegos comes back, plus a few days. All right.
And the next one, Judge, is David Luna, he's in custody, have a plea. The plea agreement. Okay. He's downstairs, already met with him. Just waiting on paperwork. Take it down and come back up.
Great. Sounds good. Let me know when you're ready. Yes.
Okay, we're gonna do a plea on Mr. Parker. I've got to get these papers.
Okay.
The new charge will encompass everything.
Very good.
And then Mr. Ross is going downstairs and doing a waiver on Mr. Mark, and I think just a regular sale on him will do, so I have plenty of time to talk.
Yeah, that's not a
about
problem at all.
his issues.
Okay, that's what we'll do.
But I am into Mr. Parker's paper downstairs. so
No
I'll
problem.
come back up.
Yeah, and you have someone to go down there with you? He's, okay. And did we find Mr. Coons? Okay. Coons?
Yes, but you got a new case, it's on a arraignment and a probation case.
Is he here?
We have not seen him.
Okay.
I don't know of him personally, but the clerk showed me a picture of him, and so we've been sitting out front waiting.
Okay. He's usually here on time. We've seen him a lot over the
I never met him.
time. Okay.
personally.
All right, well, have you had contact with him?
No, sir.
Okay. I guess your contact you need to have,
Yes.
although by text and
Right.
by written word.
Yeah, I have not received any responses or anything.
All right. Well, I don't want to hold you up too long, but why don't we wait about 10 more minutes till just before 10, and then we'll see what to do then.
Okay.
All right, thank you very much.
Thank
We'll
you.
run down to Judge Timmy's court. I'll be right.
Okay.
Normally for somebody who's hearing impaired, I will walk from here to the rotunda with sign language persons.
Okay.
Already say the name several times.
Okay. Well, let's
So I
find.
don't know if anybody's done that for you yet. So.
No, that sounds good. Well, let's do that then. When you find someone and you can do it,
So I'll wait till 10 minutes, however long.
well, you can go ahead and get started with doing that.
Can I give you these rings?
Yes.
Or readers?
Keep working on this.
Yep, go right ahead. Let's do on. Did you already reset Marco?
Yes.
What setting did you give it? Huh?
October 15th,
What kind?
free trial.
Okay. And I've signed the waiver on Mr. Merca.
Thank you.
Thank you. Anthony Torres. I signed the waiver on Anthony Torres. Signed the waiver on Mark Herrera. Ms. Solano Sequeira, can you come forward, please? Probation also. I would like you to go downstairs with probation and get a test, please. Okay. Okay, that's fine. And we won't talk about anything until he gets back here. I just want you to go and get that test. Okay, thank you. Hello, how are you? Yes, of course.
Able Valdez.
Okay.
He's not present in the program, but he was at for an official cause hearing. He did pick up a new offense, so the probation department will be submitting a violation notice.
Okay, is he's here on the, or was supposed to be here on the show cause case 22-1484? And has he already pleaded in that case?
Yes,
Okay.
he's on probation.
And can you tell if he had notice to be here? Do you believe he had notice?
The court should have provided some notice.
Okay.
We send it to whatever address probation puts on the show cause.
Have y'all had contact with him?
No, he has not been shown.
Okay. When was the last time y'all reached out to him? Okay.
It looks like he was notified, yes, sir.
Okay, thank you. Abel Valdez?
The last time we had contact with them was February 29th.
Someone tell me what his seal bond or what his original bond was?
$5,000.
Thank you.
I'm Valdez.
Yes. Please call that 3 times, please.
Yes, sir.
Did you say he picked up a new case?
Correct.
What is it?
I believe it's that.
In Hayes County or in the county? Is there any chance that he's being held in Comal?
I'm not too sure. From what we're aware of, he was released on July the 30th, the new offense.
Mr. Walker.
Just one second. 7:30, you said, July 30?
Correct.
Should have that because we have to taken care of today, but we'll give him another hour to show up. All right, thank you.
Mr. Coons was not in the hallway and none of the other partners.
Okay.
The interpreter that I took is familiar with them. I had a Mr. Flores on page 2.
We have her on the line, but. Okay. I'm waiting. Namki, can you go ask Mr. Bond if he's ready to move forward? If we have a defendant in court.
Which one is that?
Far to the left, standing up. And we have the interpreter here and the defendant here. None of these CPS cases go to, right, so they.
I'll take
So
them.
you're on this, okay.
I was gonna ask you, but I didn't know if they were off, like, what else.
They had CPS court in here on Friday, so it's probably just
Leftover.
that day.
Okay, thank you, sir.
Can I have Lee Jean Wee, please?
Yes, sir.
Are you ready, Mr. Vaughn?
Yes, Your Honor.
State someone on Lee Jean Wee. Hello, can you hear us?
Yes, Your Honor.
But I can't hear you. One moment.
Can you hear me? Can you hear me, Your Honor?
Ms. Lee, are you there?
Yes, Your Honor. Can you hear me?
Yes, we can.
Okay.
The important question is whether Jean Wee can hear you.
可以听得到我吗？李新辉 Yes.
Yeah.
Yes, I can hear you.
All right. Now I'm gonna give me one moment. I want to turn this camera so that he can see you. Can you see down there? So you
Yes,
can
Your Honor.
see?
你可以看得到我吗，李新辉 Yes.
Can you put it back where it was? I can't, we can't see it now.
Oh,
You see her. Just leave.
there. You see it now? All right. We're here today on a plea setting. And I signed some orders to keep him here. Sir, have you been in Hays County since the last time you were in court?
There's an echo, Your Honor. Can you repeat it?
Have you been in Hays County since the last time you were in court? That was in August on the 9th.
OK， 从上次的开庭之后，你有待在这个县吗？在这里
明白。
什么？
在哪县？
这个县就是这个 Harris County 这个县。
是在这儿。
Yes,
Yes, he has been in Haskell County.
yes, Your Honor.
All right, very good. That was the starting point so that your attorneys would have the opportunity to meet with you at their convenience.
OK，好的，因为这就是我的想要做的事情，这样你的律师就有方便的能够跟你一起会面。
All right, so we're set for plea. Do we have anything resolution today?
We have been offered the defense.
We would like to advance the jury trial, Your Honor.
他说他问一下检察官，你们有没有达成任何的认罪协商？你的律师说你们想要陪审团审判。
Do you understand what that means?
李先生，你明白这是什么意思吗？
我就是没有罪。
I'm not guilty.
Okay, that's what we will give you a trial for. So your next setting will be a trial setting. When you come back here, we will have a jury panel available so that we can go to trial on your case.
好的，这个就是我们下一次要跟你安排庭的时间。下一次你来的时候，我们会有整个陪审团准备好，然后你可以开庭。
好的，谢谢。
OK。
Anything from either side?
No, Your Honor.
Okay. Is there anything that you are still getting from the state so that we don't have any last minute issues?
Not that.
Very good. All right.
检方有没有问题？然后检方说没有，然后他问你的律师有没有问题，他说没有。
We will be ready for your trial, and your attorney will have appropriate clothing for you, so you're not what you're wearing right now, and we will be in front of a panel of Hays County jurors. Does that make?
好的，我们会替你的审判做好准备，你的律师会替你准备合适的衣服，在开庭的时候，不是你现在穿的衣服，这样子。Thank you.
Okay. Let's do a setting in. Yeah. Okay. Good. State, how long do you think you will need to try this? The reason it's important to tell this far in advance, and I know this will just be a gross estimation, is that we will need to have the interpreter plan.
I was 2.5 to 3 days for innocence, and then an additional day if they're going to the jury for punishment.
And then
检察官要给你一个安排合适的时间。
additional days.
At this point, I would say jury for punishment, so that's at least 4 days.
And you're looking at November 12th? Okay, so we're looking at a trial on November 12th, Ms. Ling. Sounds like it would be about 4 days. Would you be available at that time?
No, Your Honor, I'm sorry.
Oh, no. Okay. November 18th.
Oh, no, I'm sorry. November, I will be out of town. Sorry, Your
Okay.
Honor.
Do you have any in October? October 7th.
Your Honor, I will be out of town for the next couple months, so probably the court need to find another interpreter. I'm sorry.
Okay. We can do that, although you've been very helpful to us. Thank you. Let me do one more date in December. December 2nd. It's still not bad. All right.
I'm out of town for the next couple months. I'm so sorry.
Okay.
I can
No
do
problem.
Zoom, but I don't think will be a practical, while we're doing the trial, on Zoom. So I am available remote, but I don't think will be helpful for him.
Right.
Mhm.
No, we want you to be here.
Right. I'm sorry, Your Honor.
Okay, can you explain what the discussion we just had for Mr. Jingwei?
OK，李先生，他刚刚是在跟你排这个开庭的时间，他有问到10月、11月和12月，可是非常不好意思，因为我不会在德州在那个时候，所以可能法庭要给你安排另外一个一个翻译。OK，
So let's shoot for that earlier date you gave us. And we'll be in touch with y'all, the coordinator's office, to let you know when we can put it together with the interpreter.
Judge, I would ask for November 18th. This is one of the cases that is being covered by an attorney in another court. We also see a situation always says on the phone.
他跟法庭要求说要11月18号，因为那个是负责检察官可以开庭的日天。
Okay, so we're going to aim for the November 18th. I'm going to need both parties to do their very best to make themselves available, given that we have unique circumstances of finding interpreter. Okay.
现在是说要
All
求
right, we'll be in touch with you if there's any changes to that, because we can't get an interpreter on time. Ms. Ling,
Yes, Your Honor.
can you let Mr. Jing we know what we just discussed?
Yes，他们现在是说11月18号，然后呢，他希望法官要求双方都要尽力，要找到就准备好开庭，然后他们要找到翻译。OK，
Very good. All right.
OK，
Sounds like we have a plan, and we will let you know the exact date. Your attorneys will let you know that final date.
OK， 那现在我们有个计划，那我们会让你的律师会让你知道最终的日期，确定的日期是哪一天，好吗 ？OK，Thank you.
All right. Thank you, Ms. Ling. Appreciate you, all your help.
Thank you, Your Honor.
Bye-bye.
Bye bye.
Okay.
Mr. Jiggly, be excused.
Yes. Do we need to give a status setting? Becky, do we need to do a couple status settings in there? Just to make sure that he's here. That's what I'm thinking. Please explain what we're talking about there. Mr. Long, can you? Yes, Dave. He's got a letter on file.
There's no chance we'd be able to get someone as soon as October 7th. I'm assuming. I want to put it on the 12th in the event that Cyrus has a conflict.
I don't want to bump it off October 7th.
You what?
I know that's gonna be pushing it for us to be ready by October 7th.
Okay, well, let's set it for November 12th. And we'll do everything we can, let everyone know. But he's in custody and we've got to move this case. How are you?
Update on Mr. Coons, the interpreters and the people from pre-trial that have some news to update the court on.
Okay. Come on up, Lydia.
Good morning, how are you? Thank you for being here.
I asked the pretrial officer that monitors Mr. Coons. He tracked him. He is at home in Austin.
Okay, is he
And that was
coming
at
today?
9:50. I'll ask his officer to try to reach out to Coons.
Are you his officer? Oh, okay.
And he's checking right now to see if he's still at home, because I asked him an update, so,
Okay.
yeah.
Well, please let us know as soon as possible. We've got 2 interpreters that are waiting, an attorney.
What I would ask,
Until 11.
what I would ask Judge is, I'm gonna be here tomorrow in your court. I don't know.
But I've got to bring interpreters back and that, I don't know that they have time and we have them here. He needs to be here when he has notification. So,
Understand?
let him know. When he called him and told him he should be in court, he should have left immediately.
Right, he said there's no movement, but he'll reach out to him.
Okay,
Officer
well,
will reach out to Mr. Coons.
well, let us know and, he needs to be,
Here.
let him understand, right? Or he's going to have failure to appear.
Right.
And we're going to increase his bond. This is, the county's paying for a lot of people for his, we have 5 people standing here for him and the state and probation.
Yeah, everybody.
So please emphasize that to him.
Yes. we will.
Thank you.
I'll be in this little area.
Very good. Thank you. Thank you for your patience. Interpreters. Okay. Is Mr. Vaughn handling Ms. Blunt?
Yes, Your Honor.
Oh, okay, very good. You let
Like
me.
me approach?
Yes, come on up, Mrs. Blunt. I didn't see you down over there. I didn't see you. We're over there. Last time. So don't think I was yelling.
No, we're still, I still need to approach you on, Mr. Jung Wee.
Oh,
Let me forget.
okay. All right, what's our status here on Ms. Blunt?
Your Honor, I think we're here for a plea setting.
That's right.
We'd like to advance to a trial setting.
Advance the trial setting. Is there anything that you are missing right now that would prohibit you from going to trial?
No, Your Honor, since the last setting, the state has provided us with additional discovery, which they said they would, and they followed up and they did. So I believe we are good to go.
Very good. We'll move that to a trial setting. If there's some sort of arrangement that your attorney makes with the state and that you agree to, I'll take that at any time. Otherwise, the next setting will be when we come the week before to do the announcement. And he'll explain those things to you, okay? Well, your next setting will be a trial setting. I need to be clear. So let me tell you, your next setting will be a trial setting. That means that we will have a jury panel here and we will be ready to go to trial on your case. But you will come the Tuesday before that trial setting and it'll all be written on that piece of paper when we will make announcements about the state's readiness, your attorney's readiness, and how long this case will take, and whether you would go to the judge or the jury for punishment. Okay? All right, thank you very much. Yes, on June week.
Yes, so Mr. Seymour has a vacation letter on file for November the 18th.
Okay.
So I'm asking to go to the next one of December the 2nd.
Oh,
I'm sorry, the 12th, whatever it was.
Yeah, we're gonna do the 12th. We're gonna do November 12th.
He has a vacation letter.
He has a vacation letter on file for the 12th.
And the 18th?
Yes, he has a vacation letter starting November 10th all the way until the beginning of December.
Okay, well then when are we gonna do it in October?
October.
Yeah, I mean, he's sitting in jail, guys. I can't. And if, I mean, that's that far out and I respect that he has that on. So we're gonna be looking at October. Let me look at the calendar. We've got the 7th, October 7th. What do we have the 14th, Becky?
The holiday,
What do we have the 15th?
non-jury docket.
Well, we have 4 days that week. Do we just have one day of non-jury?
Yes. And the 14th, we only have the 15th. And then 2 weeks later, we only have the 29th. And then we don't have court again.
Okay, let's
until jury trial on the 12th.
Let's set it for the 15th then. I mean, he's already got, that's another month and he's already has 315 days in the court will make itself available.
Can you have the clerk order a panel?
I will. And we will order that panel for,
We already have 2 jury panels coming in for 2 other courts.
okay, we'll do it for the afternoon then. That way we don't.
What time?
What's that?
What time?
1 o'clock.
Are we gonna be able to get an interpreter for?
I'm sure I told her to just pause because the date had changed like 5
And
Right.
Judge, realistically, we have to have 30 days to be able to get our subpoenas out and served. That's, I mean, even if we did it today, we'd be outside of our 30 days. I know we're trying to get this done as soon as possible and Chris busts his butt to get people served, but between getting the subpoenas from the clerk's office and being able to enter in who served and not, we have to have that 30 days.
Okay. Well, clerk, timely get those subpoenas done, move them to the front of the list. He's sitting in the jail. He needs his day in court. The alleged victim needs to come in and tell what happened to her. We can't do November. We all have to go a little bit outside of I mean, it was a week that the court certainly wasn't going to be in trial, and I'm opening a new date for this case. So.
And there's no way we could do the 21st or the 28th.
No. Okay. Here we go. 1 p.m. Hello, how are you?
Good, how you doing?
Good. Who do you have today?
Sentencing on Giovanna Solano.
Very good.
Please, the sentencing.
I did. Do we have the results of that test? Okay. Have you had the opportunity to review the report and discuss it with your client?
Yes.
Okay. Let me just give them a moment to give me that.
I apologize. She was negative.
Okay. Well, then, are we ready then?
Yes, sir.
Very good. Can you come forward, Ms. Solano Sequeira? Ruby, are you ready?
Yes, sir.
Court calls CR 23-2471F, the state of Texas versus Giovanna Ofelia Solano Sequeira. Can counsel please make their announcements for the record?
Allison Boost for the state.
Over, Morales for Ms. Solano.
And are you the same Giovanna Ofelia Solano Sequeira, who in CR 23-2471F pleaded guilty to tampering with a governmental record?
Yes.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
That's right.
Okay, we're here today for your punishment hearing. We have received a pre-sentence investigation report from the probation office. Counsel, have you had the opportunity to review that report and discuss it with your client?
I have.
And are there any corrections or modifications to the report?
I don't believe so, other than she had a question about number 22. And it looked like it was just saying that if a cognitive class was recommended.
If they what?
If a cognitive class was recommended, that would be part of it. I just want to know about that.
That it would be part of the
Probation.
If a cognitive class is recommended, will it be part of the probation?
Yes, well, it would be, I guess. I guess that was her question.
What's your question?
So what kind of class, is there a class that I need to attend?
Yes, and they'll tell you about all of those things when they go over all of those factors, but the court, as part of the conditions of your probation, can set classes, community service,
Okay,
any sort of thing, and one of them would possibly, in this case, be a cognitive class that has been recommended by the probation office. Understand?
yes.
All right. Is there any legal reason we can't proceed to sentencing?
No.
Any argument from the state?
No, Your Honor.
Any argument from the defense?
No.
All right, having found that there was sufficient evidence to substantiate your guilt, I did not find you guilty at that time. What I'm going to do is grant your application for deferred adjudication That will be for 3 years. There will be a $500 fine. Court costs, you will pay those today. There is a $60 supervision fee that you will do, 250 hours of community service. You will also do the cognitive education program. Who was the co-defendant on this case?
Jose Hassan.
Okay, who is that person?
He is the owner of the inspection place.
Okay, do you have contact with that
No.
person anymore? All right, well, you are not allowed to have contact with him during this probation.
Yes,
Understood?
understood.
And you will do UAs as directed by the probation office. All right, is there anything else we need to take up?
Nothing from the state.
No.
All right, ma'am, I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm going to sign the trial court certification. Now, I have it. And that will be part of your file. Also, because this is a felony, you are ineligible to have ammunition or a weapon during this probation. Understood?
Yep.
All right, good luck to you, ma'am.
Thank you. You borrow your right thumb, straight up, straight down on the pad, and then straight up, straight down in the box. I don't see you again.
Steve, let's make sure that we have a plan for Coons if he gets here in time with our interpreter.
I believe our interpreter is only here for another 40 minutes or so.
I know, but that's what I'm saying. Let's make sure that you've conferred and you and the defense have a plan if he does show up. So just because, the only reason I'm saying that in this case is because those interpreters would need to start acting quickly on whatever it is if y'all have some sort of agreement.
I've already emailed him the offer. I don't believe he's had a chance to speak to his client about it, but.
Okay, all right, very good. Thank you. Probation, can I give you this?
Yeah.
Yeah.
What's that?
All
Oh,
you-
And then also this other one.
What are we waiting on?
On our client being brought up.
Who is that?
Quintanilla.
What are we gonna do on that case?
So here's the motion that you might want to just take some time to read. He's currently being held on an illegal plea.
On an illegal plea?
Correct.
Why is it illegal?
So he was indicted on a state jail.
Ms. Barado.
I just wanted some background on that.
Quiet, please.
So he was indicted on a state jail felony fentanyl case. Back in May, our office was in court and looked at it and said, oh, this level of fentanyl case is a third-degree felony now. So it should be pled out as a third-degree felony. And paperwork was done and he was sentenced to 2 years TBC. The problem was that when the case actually occurred, that charge was still a state jail felony. The law changed a couple months after he was arrested. So the defendant ended up pleading to 2 years TBC on a case where the maximum penalty was 2 years state jail.
Okay.
So, and we've got case law and stuff that just says, like, in a case like this, the best thing to do is just take everything back, put him in the spot that he was before, and then we'll have time to renegotiate a new plea that fits within the punishment range.
Which we have come to an agreement and.
You're gonna take care of it today?
Yeah, hopefully.
Okay, is he in here?
Yes, but they're not bringing.
Okay.
All
right, do you want to explain that to him and
And I can, yes, sir, I'm confirmed, and we just see what we take.
Yeah, so if you just want to give us then like 5 minutes to get the plea paperwork done, that way we can just jump straight into the new plea if you want.
Okay, do you have the order on this so that?
Is it not on there? Nope, okay, I will, also have the order so that you can sign that and then we can do the new plea right away.
Okay, and do you have the plea paperwork in hand?
No, not.
Okay.
Would you like to speak with him?
Come on up, Mr. Quintanilla. Morning, sir. I understand that there was a mix-up on your case because it was a state jail felony, not a third-degree felony. Is that what's been explained to you? Okay, so you understand what's going on?
Yes, sir.
All right, so there's a motion that your attorney and the state has put before me to withdraw that previous plea agreement that you had and that sentence that you had, and then you are going to come to a new agreement. I'm not going to get involved in that new agreement yet, but I am going to grant the motion to withdraw and set aside the previous sentence that we gave you, and we'll pull that judgment too. Understood?
Yes, sir.
All right. We'll just, your attorney's going to get new paperwork for you, I understand, and y'all can come back here as soon as you're ready.
Thank you.
False alarm.
No big. Oh, sorry.
There you're open. Do we know about Mr. Matias? Is he? Okay. Mr. Matias, we need to bring up some of your people.
I'm gonna go downstairs and go over the opinion with them.
Okay.
And then we can bring them up.
Okay, very good. And then it seems like there was a handful of.
There, Ariely.
Ariely Flores
I
Velasquez.
don't see him. I'll try to see if I can get a hold of him.
Okay.
And the other one is Ranulfo. And I will be speaking to him downstairs, with the additional evidence to review.
That's the last one there.
That's Torres Padron. Yeah, that's the one I'm talking about, DWI. Yeah.
Okay, we've been, so you're gonna talk to those two downstairs.
Yes, Your Honor.
And then Ariely, you're gonna reach out to him, although we have not had him respond.
Right.
Did you expect him to be here?
It's been, you know, we've been waiting for a good guy packet for like 2 settings now. The last setting, he said he forgot the stuff and left it at home. And so.
No problem.
On Carranza, I believe we have a plea deal, but I'm gonna go with the opinion. He's going to sign a waiver of jury trial today if he accepts.
Okay.
He agree.
Well, I'll leave that to you. I think then you'll be downstairs then.
I'll be downstairs talking to them.
And you may just want to give your client a heads up with the change in the statute. There's going to be a lifetime protective order.
Right,
So,
yeah.
just so that he's prepared for it.
Okay.
That's not, is that a recent change? And you can be civilly prosecuted. I mean, you can be civilly confined. You don't have to use your sentence.
That's not new. That's
Yeah, that's
for
been
sexual
outside.
violent offenders. Yes.
So this one is, run that line.
It's a lifetime protective order.
Okay. And I guess that's what I got.
Timothy Inholt?
Yes.
I saw Mr. Green came in. Did he say anything to you, Becky? Thank you very much, ma'am. And have we heard back from Becky? Right. From Lydia about Coons? Okay. Let's go to page 2. Carl Heights. All right, very good. Have you heard from your attorney? Okay.
He might be in jury trial in their county work college.
All right, just hang out for us. Thank you, Becky. What's going on in yours?
Still on recall, Judge.
Okay.
Still confirming.
Let us know.
Yeah, certainly will.
I'm on page 4 now. It looks like David Luna's, they're downstairs doing plea paperwork. Mr. Hindera, I saw, oh, there he is. You're working, keep on going. Then we've got Mr. Tatum's. He's here. Great. Melton with Hindera. Merca reset. Joseph Middleton is here.
Yes.
Okay, thank you. Have we heard from Mr. Evans?
He called and said he would be around 10:30.
Okay. Your attorney called and said he'd be on his way. All right. Edward Resendez. Do we know anything about that? Becky?
She was up here. She went downstairs.
Great. Juan Saldana. I didn't sign that. I didn't have a waiver on that, did I?
No.
Do we, can you tell me if you have notice to be here? How you doing, Mr. Cadams? Good, thank you for being here.
Oh, I guess I should go check. Are you okay if I reset that?
I didn't have notice, Your Honor.
You had notice?
Yes, sir.
Can you tell me what?
I sent notice to the wrong address.
What's that?
I sent notice to the incorrect address.
I don't have a problem
So we're
with
just gonna
one
reset
more
it?
uncontested.
Let's get a
second,
short
but
reset
no,
then.
I will
I got you. Juan Saldana. Juan won't change. San Saldana State. Sent to the wrong address, I understand.
The notice?
The notice.
Yes, I have to send it to the address.
Okay. We'll do that. Yes.
Good morning. I got Mr. McAfee on page 4. So I thought the offer was going to be for rehab, but the updated offer is going to be for revocation. So I'm asking for one final reset to review that with them and then review the discovery from the newest case, which is the basis of the prison revocation offer.
So we're gonna set it for, can we get him up here, please?
Okay.
Mr. McAfee, just because I need to tell him.
I'll let you know if
this
it's
case
contested.
And we're gonna set it for a contested hearing.
Yeah, I'll let you know if we're going to take it.
But I need to tell him that.
Thanks, Joe.
Yep, y'all can keep conferring if you would like.
Would you like his while you're on it?
When he comes up, I'll do it. Thank you.
Sounds good.
Ms. Dow, you're on Salcedo, correct?
Yes,
Okay, see you working. Don't let me bother you.
we're very close.
Mr. Andera, how are you?
I'm fine, Your Honor. May I approach?
Good, you've got a handful. Let's start with Quincy Walker.
Mr. Walker is in the Williamson County Jail, so we're
He
gonna
was
need.
just sentenced to TDCJ, so I have to reissue the bench.
Okay.
Yeah.
So bench warrant that, get him back, and we'll let you know when the new date will be.
Okay.
Wait, who's that on, Williams?
Quincy Walker.
Quincy Walker. Yeah, he took a 1-year. State jail.
Okay.
With 69 days credit here, so you've got about 80 days credit now. And then I have John Marmolejo. We are getting over to the mental health doctor. I need to, his mother called me and I need to somehow convince him to do a 10-year deferred.
Okay, so we need to get him up here.
I will do that, yes, if you want to, Your Honor.
Can we please get Marmolejo up?
He is, I will tell you, he's autistic and he has schizophrenia. And then Rasheed Melton, I have pleaded, as they say, for the county to show mercy and bounce his offer down, and I will check that right now.
When he comes up, so we need him to come up?
Not yet, not yet. If they bounce it down to 4 years, I'll go down and get it signed up.
Okay, well, y'all keep confirming that.
Thank you, Your Honor.
And Marmolejo will be up.
Thank you, Your Honor.
State, did y'all talk to Mr. Vestal on West?
We have, yes, sir.
Oh, it's just a arraignment. But arraignment, he's been in for 136 days. Students, come on up. Come on around. All right, you are the first of the semester to come in and see this. What do you think about what's going on here?
Right now, I think it's kind of interesting. I've never like understood compared
Right.
what I came into. So I mean, it definitely opens up my eyes more. Like kind of looking like seems like maybe a party. I don't know, like or going saying, hey, like, someone's like go back on trial.
Well, yeah, what they're trying to do is figure out what the attorneys are analyzing, how good their case is, or how weak it is, and then trying to figure out how their plea can come into that. And you see, like right now, I mean, this is the classic moment, the state's going through their cases, looking at them, the attorneys are making their argument. And, this is really what so much of what happens is, or these days.
So they're deciding if they're gonna go to trial or if they're gonna plead.
They're deciding, right. Or, sometimes they're not to that point. They may just be saying, hey, what about this piece of evidence? We don't have it, we need it, or, and they're just talking through their cases and the idea of that we had when it was on the board, that the attorneys don't have time for their cases. You see on each one of them, they're sitting here and arguing it out. And, the system does work better than we're told on social media. And you see that today. You see, a lot of the defendants are out they're not being held in custody.
Wow.
There's a lot of felony cases that are out. This one, we had more, which is interesting. I'm not quite sure why we had more. But quite a few of them, I think, were because they had not shown up to court quite a few times. And so then if that happens, then we will increase the bond. And I mean, they can make a new bond, but it just wants to emphasize to them, we have to move their cases forward timely.
Yeah.
And, if they can get out of jail on a fair bond. But then while out on bond, they have to follow certain conditions. The first one being, you have to come to court. And so, anyway, I'm glad you got to see this. I think this is interesting. It's kind of a slower day than usual. This is an interesting case because fentanyl was a lower charge several years ago when the defendant is accused to have had fentanyl. Now, because they've increased the degree for some fentanyl, we're going to have to go back and pull the old one, because they did it on the new law, but you can't be tried for the law now, when what you did, it was a different law, right? So good thing for y'all to see. So he came forward, and we've already, I don't have it here, but I'll show you, they asked to withdraw that plea.
I heard that in this.
Yeah, withdraw that plea, the sentence and everything. And I'm going to do that, 'cause it's an improper judgment against him. And now they've got an agreement on a new charge. New charge, a new degree. It was a third degree. Remember, we looked at this on state jail, third degree, second degree, first degree. State jail is 180 days to 2 years in the state jail facility. Now, what's unique about that one? What do you remember?
You
What's that?
can get
Day to day. Good work. I like it.
You can get parole.
Yeah, the other ones, right? You can't get out on those. On the third degree now is what he had. Now it's going to be a state jail, so it's going to be day for day, and we'll see how that changes the negotiations. I don't know yet. The female who wasn't here was from Public Defender's Office. This attorney is from Public Defender's Office. They're both very strong. They argue for their clients very well. You know, what was said on our first day about public defenders, I find to be, but I want you all to see it. I'm not going to tell you and try to convince you. I want you to see they're coming in here fighting and doing a good job for their clients, and you know, people can have confidence in that. What are the questions y'all have?
I heard you saying reset, I think.
Reset, so
Pushing back a date?
yeah,
or-
so it just goes to another pretrial setting.
Oh.
So we really have three settings here. We have the pretrial setting, we have the plea setting, and then we have the trial setting. There will be multiple pretrial settings, and that's when the attorneys are discussing their case, they're receiving discovery and looking at what the evidence is. Discovery is the evidence. They're looking at all the evidence against the client, and the state's looking at it, and they're deciding what is a fair offer. The state's going to make an offer to them, a plea offer. And then after several of those, and then we will move to a plea setting. That does not mean the defendant has to plea. It just means that they know that it's kind of the last stop before a trial setting, just so it's fair for them to know the status of their case. So then we'll always do a plea setting before the trial setting. Again, does not mean they have to plea. And then we'll have the trial setting. And they can still plea on that one, but that means that day they are set. The jury panel will come in, and we'll see if their trial goes forward.
That's why, yeah, like the defendant, she came up and she like played earlier.
She what's that?
The defendant played earlier.
So what that was in a good question, that I want y'all to see a plea, because you'll see how we go through all of the defendant's rights. But what we're doing on that one is someone has a plea agreement where they're going to get probation. That's the agreement that they made. So then I get a report from the probation office. They go and do research on that person. They do an interview with that person. They find out what it is, sort of classes and what they need to do better, you know, because probation's, we're going to have, they're not going into custody. We're going to ask them to do certain things, like take a course, like that woman has to take a class. And we figure out what are the things that they need to do. They bring that to me, and then she comes back and we do the sentencing. And that's what you saw on that one.
So they kind of give you like what the plea will be, or like the.
They tell me what the
sentence
plea is,
will
but
be.
then they give me her history. They tell me her criminal history. They call it drug history, if any, on any of those. You know, I'm not saying that she did or didn't.
Are you able to talk about what the case was?
What's that?
Are you able to talk about what the case is?
Sure. Hers was a tampering with a government document. Do you have the file on your Solanos Siqueira? Let me take up a couple of these and we'll bring you right back up. All right. Hello, Mr. Green. How are you? Good. Yeah, of course. Thank you for your patience.
Of course, no problem. I'm here for Timothy Entholt.
Yes, Mr. Enholt, come on up, please.
Do you want this one as well?
Yes. How are you, Mr. Enholt? Thank you for being here on time. All right, we are here on a pretrial setting. Do you have an offer?
Oh, we have an offer, Judge.
Okay. And do you have discovery?
We have discovery. I was gonna ask for one more pretrial setting to go over discovery with my client, then make decisions from there.
Very good. We will do that reset. Just after you get that reset, make sure you come back on that date. If your attorney's asking you for anything, he's relying on you. So make sure that you're communicating with him. All right. Are you, what is this charge?
Theft with 2 priors.
Okay. Are you staying clean right now? Okay.
I had a gambling problem. Anyway, I'm doing a lot of move on from the
Okay.
situation 3 years ago.
Well, make sure that you're staying clean. That's one of your conditions of bond.
Oh, yes, sir, yes.
Okay, and if you're clean, then you can take care of these other issues, but that's kind of our first stop.
Yes, sir.
All right, thank you very much.
Thank you.
Thank you. Thank you, Mr. Green. Thank you. Okay.
Oh.
We're gonna take a plea on his next. Okay.
And you're just saying right there, what we're gonna do is we're gonna go through a plea now, and what I want you to see is just all of the things that we're going to do to make sure the defendant understands what he is doing in his case. So protect his rights, and so we're gonna ask about a lot of them. And I'm gonna try to do it at a rate that's not too fast, so that that woman right in front of you does not come down on me too hard, because she's taking down everything we're going to do.
Josiah, continue. Judge, did we give you the order?
Yes, I already said it, pass it off. Who are you here for?
Mr. Parker, bring him to plea when they bring him.
Okay, let them know. Yeah, and let's try to do it, because we've got that. We need to do, as soon as he gets up, we will move that to the front of the line, because we have the interpreters. We got to get them out of here. Any word on Coons?
Oh, Lydia let me know that his GPS tracked him at home.
Okay, he's not
And that
coming.
his officer is texting him.
Okay, do we release those interpreters? Not for yours, for the other one. But they can be released. And then we need to talk about, where is he? Deputy Donkey, we need to talk about the bond on that case with the interpreters. We'll get to it. Are we ready here?
Yes, sir.
All right. Movie? Court call CR 23-3322F, the state of Texas versus Josiah Edward Quintanilla. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Christine Parado for the defendant.
And are you the same Josiah Quintanilla, who in CR 23-3322F is charged with delivery of a controlled substance, fentanyl, less than 1 gram?
Yes, sir.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. This is, at the time of the allegation, a state jail felony. State, what is the range of punishment for that state jail felony?
Not less than 180 days, not more than 2 years in a state jail facility.
Do you understand that is the range of punishment that you face for this charge?
Yes, sir.
I have paperwork before me that indicates you would like to enter into a plea bargain agreement.
Yes, sir.
I'm showing you what is labeled the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt, to say that you are guilty. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Defense, have you, hold on. Here it is. I have the discovery compliance statement before me. Are you satisfied that the state fulfilled its obligation to give you evidence in accordance with Article 3914?
Yes, I am.
And do you believe that Mr. Quintanilla is competent to enter into this plea today?
Yes, Your Honor, I believe he's competent.
The reason we talk about that evidence is because you have the right to know the evidence against you in a case. Did you discuss the evidence with your attorney?
Yes, sir.
And do you believe that your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. According to the plea bargain agreement, in exchange for your plea of guilty to delivery of a controlled substance, fentanyl, less than 1 gram, the state will recommend 12 months in the state jail facility. You will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, Your Honor.
And would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of delivery of a controlled substance, fentanyl, less than 1 gram, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
State, have you given notice to the victim in this case of the proposed resolution today?
Yes, Your Honor, the state of Texas is aware.
Well, I think there's a complainant that's in here because you have to sell to someone.
Judge, that person,
The state of Texas is aware.
I was wondering what you were getting at, Judge.
Well, just a regular possession would not be, but
Correct. Your Honor, yes, he is aware of, based on phone conversations that we had with him back in July after the original plea was taken. Yes, he's aware.
thank you. All right, based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason we can't proceed to sentencing at this time?
No, not from the.
State,
Nothing from the state, Your Honor.
any argument from state?
Just to follow the plea agreement, Your Honor.
Defense?
I'm saying no.
All right, having found sufficient evidence to substantiate your guilt and having found you guilty for delivery of a controlled substance, fentanyl, less than 1 gram, the court now sentences you to 12 months in the state jail facility. You will get credit for the time that you have served. There is no fine or fee. The attorney's fees will be waived. Is there anything else we need to take up?
Nothing.
No, Your Honor.
Sir, I followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Good luck to you, sir.
Right down, straight down, straight up. Perfect.
You're right, Mr. McAfee, we're ready.
Okay, what are we doing on this record?
We're telling them that the next setting is going to be a contested revocation setting. We got an updated offer this time. We're resetting it for contested setting.
Okay, yeah, we'll do that real quick. Come on up, please, sir. Mr. McAfee, we're here on a motion to revoke your probation. I've heard from the attorney for the state and from your attorney that we're going to set that for a contested hearing. We will come back, and at that time, the state will have its witnesses, and unless you all work out some resolution. If there is a resolution before that, I'll be happy to take it. All right, anything else we need to take up?
I will let the state know if we've got a resolution at least 10 days before whatever date I get right now.
And Judge, just so that the court is aware, we have requested the additional discovery from the Austin Police Department. At this point, we haven't received it, but as soon as we get it, we will turn it over to defense.
Very good. All right, thank you.
Your Honor, may I have your signature on these?
Yes. Are we ready on Ms. Brown's? Just because we have an interpreter here. What do you have, Mr.
I
Indera?
have Mr. Marmalade, hello.
And what are we going to do on it?
We are going to move into the plea docket. We're going to talk to them about it.
About removing that? Okay, we can do that real quick, and then we will do Mr. Parker next. Is he up?
He's on his way.
Okay. Yeah, because we've got interpreters that have to get moving. Did you just need one signed?
Yes, sir.
Marmalade.
Yes, sir.
Thank you. All right, Mr. Marmolejo, we are here on a pretrial setting, but I understand that our next setting will be a plea setting. Is that right?
Yes, sir.
That does not mean that you have to plead, but if there is not some sort of resolution, then the setting after that will be a trial setting. I just let you know so that you understand the timeline of your case. Does that make sense? Okay, so your attorney can continue to confer, and if you all reach an agreement at any time before that setting or even at that setting, I will take it. But that gives you a timeline of kind of 30 days out for the next plea setting, and then after that, if there is no resolution, the next setting would be about 30 days after that for a trial setting. Understood? All right, thank you very much. Yes, thank you. All right, yes.
On
Mr. Coons?
Coons matter, I know ladies had to leave, I believe at 11.
Okay. I
State's
understand.
gonna move for bond forfeiture, Judge.
Okay. Thank y'all for being here. Thank you for your patience. You're free to go about your business.
Thank you.
I understand that he's still at home and so he's not going to be here timely. So thank you very much for being here today. Appreciate it. Would you like to be heard?
Judge, I don't know if the court would be willing to maybe see if he showed up by a certain time to hold it in the band.
Now we can. I mean, I guess you could talk to him via writings.
I anticipated that as well. I gotta leave to Austin myself.
Okay.
But yeah, I was wondering how the heck we'll do that other than maybe writing down things, but.
Okay, well, here's what we'll do. We'll set it. If he's here at 9 a.m. tomorrow, I'll consider not forfeiting his bond.
Absolutely.
But
Okay.
he has until 9 a.m. He needs to be in court tomorrow. I don't know that we'll have an interpreter, but you'll have to write things out.
I'll be here. You're all right. I have a client here tomorrow anyway, so it worked out good for me.
Okay, very good.
Okay, see you tomorrow. All right.
So I just wanted you to know that this pretrial officer IM'd me. He did not appear on Friday for his meeting with them as well.
Okay.
And as of right now, his GPS is locating him at home, not en route to Ace County Government Center.
Okay, well, let him know he has until 9 a.m. I'm trying to give him a break.
Let me give you a reset.
Okay. That's an indictment, and that tells what the formal charges are. Who do you have? Okay, very good. Ariete Flores Velasquez. Deputy, can you call that one 3 times?
Yes, sir.
And can someone tell me what the bond amount was? Flores Velasquez, page 2, number 1.
The count 1 was $4,500 and count 2 was $3,000.
Please call it 3 times, then we'll come back and discuss.
Yes, sir.
Have you heard whether Mr. McCray was going to join us today?
They called and left a voicemail somewhere. I'm not sure if it was before or with him.
Okay, Mr. Heights, please just continue to wait. Thank you for your patience. William Love. Is Mr. Hale downstairs?
Mr. Hale is outside speaking with Philip and Mr. Cox.
Very good. David Luna, we have a plea on that one? Okay, good. Well, the light was reset to plea.
And we're still waiting to get Mr. Parker back up for a plea.
Yes. All right, there he is. So what's happening over there now is he's going to take a plea and the clerk has to go and swear them in to all the information that they provided in their plea paperwork. She's doing that right now. She'll come back and then we'll do a plea on that case. I think we have one other plea. Be good to see those and then probably you guys can get going a little early unless there's something that looks novel that's coming up, but I don't see anything. Y'all can get on going, but let's get those two done because I think you see in the plea we go through a lot of his rights and make sure that they understand what it is they're doing.
Yeah.
How are you?
Weather.
What's that?
I'm good. We're just talking about how beautiful 2 weekends ago it was.
Oh, I know it. Weren't we lucky?
This weekend wasn't too bad, but last weekend was.
No, it was hot. It was hot this weekend.
Yeah, but I
Thought it was
watched
hot.
TV from the pool. But 2 weekends ago, I felt like I was up north, ready to go pick apples.
No.
So
Pick apples. That's what you think when you have fall weather is
yeah,
picking
from
apples.
Nebraska.
Oh, okay.
Yeah, it's apple season.
Is Nebraska apple territory?
Along the river, Nebraska is green on the river, on the Missouri River.
Okay.
And then it turns into plains, prairie as you go west.
Are you from the
Yeah.
green part or the plains part?
The green part. Omaha and Lincoln are pretty much in the fertile farmland. And then it gets more arid as you go west.
Right.
And up to South Dakota. Yeah. We know we always do it.
Are we ready? Parker?
Yes, sir. I am just standing.
Okay. Come on up, Mr. Parker, please. So what are we gonna do on his other case?
We're gonna ask that you reject our original plea agreement, Your Honor, and reconsider a new offer that we have.
On that case, on the
original
robbery?
And the new one. It's gonna resolve all of the issues pending, yes.
And so do we have new paperwork on
On both.
Oh, okay.
Okay, that's what took a while.
And you have the files
Oh,
here.
very good. Ruby, are you ready?
Yes, sir.
The court calls CR 23-4756C and CR 24-2677F, the state of Texas versus Sean Parker. Can counsel please make their announcements for the record?
Allison Boost for the state.
Victoria Brown for defendant.
And are you the same Sean Parker who in CR 23-4756C is charged with 2 counts of robbery and in CR 24-2677 is charged in count 1 with burglary of a building and count 2 in engaging in organized criminal activity? Is that you?
Yes, Your Honor.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
And we have an interpreter here who is signing for the defendant. Interpreter, can you please identify yourself for the record?
Sean Whitley, ASL interpreter.
And can you raise your right hand? Do you swear that the interpretation that you will give will be true and accurate?
I will.
Thank you. All right. Your charges here of robbery in count 1 and count 2 are a second-degree felony. State, what is the range of punishment for a second-degree felony?
Not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this case?
Yes, Your Honor.
Now, in this case, you have already signed some plea paperwork on that case. Counsel, what is the intent of what we want to do on that initial plea agreement?
The initial plea agreement, Your Honor, we're asking to reject that plea as it was a plea for a deferred adjudication. However, the defendant has since renegotiated with the state for a commitment. So it would require rejecting the initial plea.
The previous plea will be rejected, and we will move forward with the new plea agreement. Do you understand what that means?
Yes.
We are no longer following the agreement that you made previously, but now we're moving forward with the new agreement you have signed on these robbery cases.
Yes.
In CR 24-2677F, you are charged in count 1 with burglary of a building. That is a state jail felony. State, what's the range of punishment?
On a state jail felony, it's not less than 180 days, no more than 2 years in a state jail facility, and a fine not to exceed $10,000.
Do you understand that's the range of punishment that you face for that count?
Yes.
And you've also been charged with engaging in organized criminal activity in count 2. That is a third-degree felony. State the range of punishment.
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment?
Yes, Your Honor.
I have before me paperwork in both cases that indicates you would like to enter into a plea bargain agreement. I am showing you the paperwork in both of those cases. It's titled The Written Admonishments, the Waiver of Right, and Stipulation of Evidence. Have you been through these packets with your attorney and discussed the contents?
Yes, Your Honor.
On page 4 of each, there is a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you would be waiving these rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence, page 5 in both cases. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page of both packets?
Yes, Your Honor.
Mr. Parker, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes.
Are you a citizen of the United States?
Yes.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's obligation to give you evidence under Article 3914. Are you satisfied that the state has fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Parker is competent to enter into this plea?
I believe he is.
Mr. Parker, the reason we discuss the evidence is because you have the right to know what that evidence is. Have you discussed the evidence in both cases with your attorney?
Yes, Your Honor.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty in the robbery case, the state will dismiss one count of robbery and will recommend 2 years in the Texas Department of Criminal Justice. You will get credit for the time you have served. There's a restitution amount on here, but then it's not checked. What was the intent there?
No restitution required, Judge. Sorry, we were working with some of the old paperwork.
Very good.
It's Walmart that's the victim, so.
Is that your understanding of the agreement in the robbery case?
Yes, Your Honor.
And in the CR 24-2677 case, burglary of a building and engaging in organized criminal activity, in exchange for your plea of guilty, the state will dismiss the burglary of a building charge, will move forward on the engaging in organized criminal activity. The state will recommend 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. There will be an affirmative finding of gang activity. Is that your understanding of the agreement?
Yes, Your Honor.
And would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of robbery, how do you plead?
Guilty, Your Honor.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
State, have you given notice to the victim in this case of the proposed resolution?
We have.
Court finds in CR 23-4756 that according to the stipulation of evidence in your plea of guilty, there is sufficient evidence to substantiate your guilt, and I find that you are guilty. In CR 24-2677F, to the charge of engaging in organized criminal activity, how do you plead?
Guilty, Your Honor.
Are you pleading guilty because you are guilty and for no other reason?
Yes. Yes, Your Honor.
State, have you given notice to the victim in this case of the proposed resolution?
We have.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt and find that you are guilty. Counsel, is there any legal reason we can't proceed to sentencing at this time?
No, Your Honor.
Nothing for the state.
Any argument
No, Your Honor.
from the defense?
No, Your Honor.
Sir, in CR 23-4756C, the court having found you guilty of robbery now sentences you to 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. In CR 24-2677F, having found you guilty of engaging in organized criminal activity, the court sentences you to 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. There will be an affirmative finding of gang activity in that case. Is there anything else we need to take up?
I would request that you find my client indigent, Your Honor. I am court appointed. He's been incarcerated a great period of the time the cases have been pending. I'm asked that we waive court costs and any type of court appointed attorney's fees.
Very good. That will be granted.
Thank you.
Sir, I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification that will be added to your file. In addition, I must let you know, because these are felonies, you are ineligible to possess a firearm or ammunition. Do you understand?
Yes, Your Honor.
All right. Good luck to you, sir.
Thank you. Good afternoon, Your Honor.
May I be excused, Your Honor?
You may. Thank you very much for being here.
Yep. Judgments and dismisses.
Allison, on the 2023 case, the first count was a dismissal, correct? 2023 is the second. Thank you.
I like to make it as complicated as possible, just to keep us both on our toes.
Thank you. I appreciate that.
These in that agreement, they said they were going to dismiss certain cases, and they give me those documents for those. Yep. There are also judgments that show what. Those are the official documents that will go with this case, showing everything that we did, and the state prepares those. Okay, formal first name, is that how you do it?
They should know who I am.
The reputation precedes you.
That's right.
All right, who do we have next?
Mr. Luna.
Mr. Luna. How you doing, Mr. Luna? Are these other cases pending in here yet, or you're just going to decline them? Okay.
Correct.
Ruby? Court calls CR 24-1076F, the state of Texas versus David Luna. Can counsel please make their announcements for the record?
Allison Boost for the state.
Anthony Mendoza for the defense.
And are you the same David Luna who in CR 24-1076F is charged with theft, 2 prior theft convictions?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
These, you can put your arm down. This is a state jail felony. State, what is the range of punishment for a state jail felony?
It's not less than 180 days and no more than 2 years in a state jail facility and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this charge? I have paperwork before me that indicates that you would like to enter into a plea agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents? The whole packet? Very good. If you would, just make sure to let me finish, because she's taken down everything we say. That way we're not talking over each other. If you have any questions, please feel free to let me know. On page 4 of this paperwork, the list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
So this is an agreement between you and the state. I don't have to follow this agreement, but if I don't, I'll allow you to withdraw your plea. You can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plead at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States? If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
Yes, sir.
And do you believe that Mr. Luna is competent to enter into this plea today?
Yes, sir. Please.
The reason we talk about the evidence is because you have the right to know the evidence against you in a case. Did you discuss that evidence with your attorney? No. It's okay. It's okay. My question is that because you have the right to know the evidence against you in a case, did you have the opportunity to discuss that evidence with your attorney?
Yes, sir. We discussed about it.
Very good. And do you believe that your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, sir.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will decline 2 new cases. They will recommend 12 years and 12. That would be months, of course, since it's state jail, but let's indicate it. They will recommend 12 months in the state jail facility. And they will give you credit for the time that you have served. Is that your understanding of the agreement? Would you like to enter into that agreement now? To the charge of theft, 2 prior theft convictions, how do you plead? Are you pleading guilty because you are guilty and for no other reason? Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt. State, did you give notice to the victim of the proposed resolution of this case?
So I don't know that we have, I believe it's a store. I don't know that they qualify for notification under the statute.
Does their manager not get notice?
I don't know, to be perfectly honest, Judge.
Well, let's try to let them know if we can. And I think the idea is even businesses have the right to know that their cases are being handled by the court.
We typically do.
Thank you. All right. Having found you guilty, is there any legal reason we can't proceed to sentencing?
None for the state.
Any argument?
Nothing from the state.
Judge, the only thing I would add is that if he was appointed indigent in custody for a little over 30 days, that's it.
I'm sorry, a little over.
A little over 30 days, I believe 36 days, Judge, that's the court cost and court record fees.
Very good, that would be granted. Having found you guilty of theft, 2 prior theft convictions, the court now sentences you to 12 months in the state jail facility. You will get credit for the time that you have served. Is there anything else we need to take up?
Nothing for the state.
Sir, I have followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. In addition, I must let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. That order will also be added to your file. Good luck to you, sir.
I have a question.
Yes, sir.
Do I get my discharge in when I do get there, or do I get 8% of that time, or I don't know how that runs?
And I don't know either. That runs through corrections and corrections.
They don't know all that paperwork.
What's that?
Don't know my paperwork when I get.
Yeah, they'll get
there.
all.
My discharge date.
There will be in the judgment, everything that we've discussed today, that you have 12 months in the state jail facility. Then, once corrections gets that and they apply any time that you've already served, then they will plan your discharge date. All right?
Yes, sir.
Good luck to you, sir.
Thank you.
Thank you.
Real quick. Straight up, straight down, straight up, straight down the box.
Can you please call me?
Sir.
Thank you. Thank you.
Thank you. Good luck to you. Let's do one before you.
The judge of dismissal. For you, with dismissing it pending further investigation. Looks like it was indicted a little hastily and we need more information. It's a large white collar case.
Have you given notice to the victim of the plan here?
Yes.
Thank you.
They are appreciated.
The number is CR 23-5762F.
Reminder guys, when we have off docket stuff, you make sure that Becky gets the case number and I'll come on with it.
On this, Julian Hernandez, you were going to the DWI. Did you find out what he needs and do you know when he can get those?
Does it actually exist?
What's that?
It doesn't exist. It does exist. It's already been sent to him, but to be safe, I resent the link.
Okay. Information provided today. Is that fair?
Yes.
Great. Thank you very much.
Yes, Judge.
What are we doing on these two? Dow. All right, we all probably have an idea. It looks like we're going to take a couple more pleas. That's kind of what we do by the end of the day. Y'all have any questions? All right. What do you? So I'll send out the topics for you all to put in, then you get credit for it when you do those. Usually we'll have it due by about 5 o'clock tomorrow. Same thing for what we're doing in class today. So any other questions? What do you think of this? Yeah, isn't it? It's not what you really see on TV. Yeah. There's a lot of moving parts going on here. We're looking after a lot of people. Well, I'm glad y'all were here. We'll see you in class. We have a really interesting speaker today. And so kind of look before we come in, look on that chapter 2 about federal courts and how they run, and it'll just help you understand more of what he's talking about. All right. Thank you guys. See you. Good to see you today. We ready on yours?
We are.
All right, come on up.
Which is this? Gustavo Saucedo.
Good morning, Your Honor.
How are you doing?
Just fine, sir. How about yourself?
Good, thank you.
Excellent.
Ready, Ruby?
Yes, sir.
Protocol CR 240405F, the state of Texas versus Gustavo Saucedo. Can council please make their announcements for the record?
Allison Boost for the state.
Kristen Dow representing Gustavo Saucedo.
And are you the same Gustavo Saucedo who in CR 240405F is charged with possession of a controlled substance with intent to deliver cocaine 400 grams or more?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. According to the degree on the indictment, if it is 400 grams or more, is that by itself a first degree? And then with intent to deliver, it increases the range of punishment?
I believe that's correct, Judge.
Okay, so as indicted, what is the range of punishment for this charge?
I believe it would be a minimum of 15 years, Texas Department of Criminal Justice, not more than 99 years or life.
Are there enhancements on the indictment? I don't remember.
So it's intent to deliver,
Okay.
which would enhance it.
Yeah.
Because 400 grams or more are going to be a first degree as it is, and then the intent would add it to a minimum of 15 years.
Correct.
I don't recall if it's 10 or 15. I'm double checking.
It's 10?
Yeah.
Okay.
And
Stand correct.
I don't remember the indictment. I apologize. I don't remember if computers are on there or not.
There are not.
Okay.
Okay. The bottom line is that we need to make sure that you understand that the range of punishment that you face for this charge is a minimum of 10 years up to 99 years or life. Do you understand that that is the range of punishment?
Yes, Your Honor.
I have paperwork before me that indicates you would like to enter into a plea bargain agreement. I'm showing you what is labeled the court's written admonishment, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
On page 6, there is a signature here. Is that your signature?
Yes, Your Honor.
And one other page that I need to mention to you is on page 5. There's a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, you still wish to proceed with this plea agreement.
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor, I am.
If not, a plea in a case like this could have serious consequences. Council, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914. Are you satisfied the state fulfilled that obligation?
Yes, Your Honor.
And do you believe that Mr. Salcedo is competent to enter into this plea today?
Yes, Your Honor.
Mr. Salcedo, the reason we talk about the evidence is because you have the right to know what the evidence is against you in a case. Did you discuss that evidence with your attorney?
Yes, we do.
And do you believe that your counsel has provided you with effective assistance of counsel during the course of this case?
Yes, she has.
According to the plea bargain agreement, in exchange for your plea of guilty, the state will waive the intent to deliver in this charge and will recommend 12 years. Texas Department of Criminal Justice, you will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, Your Honor.
And would you like to enter into that agreement now?
Yes, sir. I would.
To the charge of possession of a controlled substance with, not with, let me start that over. To the charge of possession of a controlled substance, cocaine, 400 grams or more, how do you plead?
Guilty.
Are you pleading guilty? Because you are guilty and for no other reason.
Yes, sir. Your Honor. Yes, sir. Your Honor. Guilty.
Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason that we can't proceed to sentencing at this time?
No, Your Honor.
Any argument from the state?
No, Your Honor.
That's
No, Your Honor, we're asking the court to follow the agreement.
having found you guilty of possession of a controlled substance, cocaine, 400 grams or more, the court now sentences you to 12 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. Is there anything else we need to take up?
We would request court costs and court appointed attorney fees to be waived, as he will be in TBC, and when he gets out, he's already significantly behind on bills due to this offense. His house was foreclosed on him, and he lost his job, and several other issues happening financially as well.
Will be granted. Sir, I followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal. I've signed the trial court certification and that will be added to your file. In addition, I must let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. Understood?
Yes, sir.
All right,
Yes,
good
Your
luck
Honor.
to you, sir.
Thank you, Your Honor. Thank you, prosecutor.
Thank you, Your Honor.
Thank you, Your Honor.
Before you
Have a
leave,
good
I
day.
need to borrow your right thumb for just a minute.
Yes.
Can I just look at this?
Yeah. Straight up, straight down on the pad, and then straight up, straight down in the box.
There you go. Yes, sir.
Mr. Vessel, what do we have?
I have the gentleman who's being brought up.
Thank you.
Okay, great.
This, the paperwork says 2:30, so to be honest, I'm not sure which one is right. He's been in since January 31st.
He gets benefited out, so if this one's higher, we'll throw it up.
Okay.
Yep.
And they said that the transfer list was nine, and that's what.
Your Honor, I apologize for keeping you waiting earlier. There was an emergency phone call.
Oh, no problem. I didn't have any problem with that. I know you guys are always working hard. So why on the judgment does it say attorney is neighborhood defender service versus the attorney's name?
That is who our appointment orders go to, and then from there, we assign it to whichever attorney in our office.
But it seems that ultimately there is a attorney that's responsible, right? I'm just talking out loud. It seems that we should have the attorney, not an entity as the.
I have whiteout.
All I know is the appointment order says neighborhood defender service, so I don't know if the judgment needs to match the appointment order. I have no idea.
Interesting.
And then
Philip
you-
has an opinion. I know he does.
I have no opinion, Judge.
It's not true. You're just not going to give it.
I'm saving all my opinions for this case.
Okay, well, I'll keep you working. Yeah, it just seems that because there will be questions in the future, if there are, who is the attorney?
and then they'll say neighborhood services, and then, but that doesn't tell them who the attorney was.
Right.
So I think we ought to.
It is on the record when you asked my name, I said my name.
That's right.
Neighborhood Defender Service.
That's right. Who, counsel, for when I ask you to announce counsel, so that's why it seems to me then too, that attorney for the defendant should be listed. Let's do that. Let's do it. Let's do it.
Can we do,
I think that's
well,
right.
like Neighborhood Defender Service dash Kristen Dow?
Yeah.
Okay.
You want to just write that in?
Sure. And I will say, sometimes we fill in for each other.
Right.
As well, so.
Well, and it'll just be the person who ultimately is in here taking the plea right now.
Okay.
Because for instance, if another judge took it, they wouldn't put my name on it, even if it was in this court, right? So that's why it's whoever is here on the time of the judgment.
Okay.
All right.
Thank you.
Thank you.
May I be excused?
Yes, ma'am, of course. Thank you for being here today. You ready?
Ready for a custody plea?
Okay. Come on up, sir.
I'm Dustin West, Your Honor.
Dustin West.
Yes, count one and count two, so there'll be two sets of papers.
There's not one.
Both are released for time. My name is Rick Vestal and the defense attorney.
Very good. Ruby? Great. Court calls CR 24-1894F, the state of Texas versus Dustin Harley West. Can counsel please make their announcements for the record?
Allison Boost for the state.
Rick Vestal, ready for the defense.
And are you the same Dustin West who in CR 24-1894F is charged in count one with theft, two prior theft convictions, and count two, possession of a controlled substance, methamphetamine, 4 to 200 grams?
Yes, sir.
Can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
The theft, two prior theft convictions is a state jail felony. State, what is the range of punishment for that charge?
Not less than 180 days, no more than 2 years in state jail facility, and a fine not to exceed $10,000.
Do you understand that that's the range of punishment that you face for that charge?
Yes, sir.
There's also in count two a charge of possession of a controlled substance, methamphetamine, 4 to 200 grams. That is a second degree felony. State, what is the range of punishment for that charge?
No less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that's the range of punishment for that charge?
Yes, sir.
So I have before me paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you gone through these packets with your attorney and discussed the contents?
Yes, sir.
On page 4 of each, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, sir.
On page 5 of both documents, there is a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And there is a signature on the final page. Is that yours?
Yes, sir.
Is this your signature on the second packet?
Yes, sir.
Sir, this is an agreement between yourself and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
And would you like to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, this case could have serious consequences. Counsel, I have before me the discovery and compliance statement regarding the state's duty to give you evidence in accordance with Article 3914. Are you satisfied that the state fulfilled that obligation?
I'm convinced that they're compliant.
And do you believe that Mr. West is competent to enter into this plea today?
Absolutely.
The reason we talk about the evidence is because you have the right to know what the evidence against you is. Did you discuss that evidence with your attorney?
Yes, sir.
And do you believe your attorney has provided you with effective assistance during the course of this case? According to your plea bargain agreement, in the theft case, in exchange for your plea of guilty, the state will recommend 180 days state jail. You will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of theft, 2 prior theft convictions, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for
Yes,
no
sir.
other reason?
Yes, sir.
State, have you given notice to the victim of this resolution?
Double check, Judge. Yes, we have.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt in count 1. In count 2, possession of a controlled substance, methamphetamines, 4 to 200 grams. How do you plead?
Guilty.
I think I need to tell you beforehand what you're pleading, the plea bargain is. For that count 2, it's 2 years TDC, and you will get credit for the time that you have served. Is that your understanding of that agreement? Would you like to enter into that agreement?
Yes, sir.
To the charge of possession of a controlled substance, methamphetamine, 4 grams or more, but less than 200 grams. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence in both cases to substantiate your guilt. Is there any legal reason we can't proceed to sentencing at this time?
None from the defense.
None from the state.
Based on your plea of guilty, and my finding of guilt in both cases, the court sentences you in count 1 to 180-day state jail. You'll get credit for the time that you have served. And in count 2, 2 years in the Texas Department of Criminal Justice, you will get credit for the time that you have served there. Is there anything else we need to take up?
Nothing for the defense, Your Honor.
Nothing from the state.
Sir?
Actually, Judge, if there is, I would like to point out to the court that my client was found indigent at the time of arrest. That circumstance has not changed and doesn't figure to change while he's incarcerated. We would ask that you waive all costs and other fees at your discretion.
Granted. Somebody get that phone. I'm just kidding, Lydia. All right. Because I followed your plea bargain agreement, you do not have a right of appeal. I've signed the trial court certification. Those will be added to your file. In addition, I must let you know that these are felonies because you're ineligible to possess a firearm or ammunition. Understood?
Yes, sir.
All right. Good luck to you, sir.
Thank you.
Thank you, Judge.
Thank you for being here. Thank you for your patience today.
Bar your right thumb real quick. Straight up, straight down, and then straight up, straight down in the box. And one more. And box, please. And there you go.
Thank you.
Judgments on those.
Any word from McCray?
He should be here in.
Okay.
Last week, or he was about 25 minutes away and that was at 11:10.
All right, Mr. Heights, your attorney should be arriving anytime now.
And John Evans is on his way as well. You exit the way.
Can I see the Heights, please?
Your Honor, I've had no contact with Ariety Flores Velasquez. I cannot leave a message. His phone is not set up for that. I texted him. I've received no response.
Okay. Can I have that one too?
I think he's on the plea doc.
Yes. Did
Yes.
you call his name?
I did, sir. I called the name 3 times. There was no response.
Thank you.
I've not done nothing.
Let me
State on Flores Velasquez, any argument on the bond?
We're just gonna move for bond forfeiture, Judge.
Any argument, Mr. Matias, on bond?
No, Your Honor.
Very good.
So that he is indigent, I ask the court to keep that in mind.
Very good. Bond to 15,000 on ag assault with deadly weapon. Excuse me, 20,000. And 10,000 on count two.
Conversation between the judge and
20,000 on the aggravated assault. Flores Velasquez. $20,000 on aggravated assault with a deadly weapon. Cash surety and unlawful possession, 10,000. Okay, thank you. Are you all ready? I'm sorry?
We want to just give you an update.
Okay. Is this your client here?
He's just there downstairs with the Sundays. We just want to give you an update.
Okay.
You have to go, you got him off the state. You got that, you know, just between asking some questions about.
Okay.
We'll be down there. We'll come back up. I know he was early on the docket, so.
Okay.
just wanted to let you know.
Okay, so are we, what we're gonna do then is reset this for tomorrow. So if y'all have an agreement,
No, he doesn't have an agreement yet. He hasn't taken the plea yet.
right?
Right.
Are you, do you expect that?
No.
Okay, well then, let's get him up here so I can talk to him.
Okay.
Okay? That is,
We can, we'll, I guess, Mr. Resendez.
rescind this, okay.
He was just taking downstairs.
Oh, shoot, I'm sorry, guys.
We're gonna go talk to him real quick just to finalize any questions he has.
Okay, well, I need to talk to him and tell him what the status of this case is. Okay? So let's get rescind this, please. And then y'all can, you can then go down and talk to him all you want.
Right, tomorrow,
Well, if you're gonna tell me, what was the setting?
the police setting, Judge.
Okay, well then I just have to tell him that we're moving it to a trial setting. Okay? Very good. Y'all just step back and when he gets here, we'll handle it. What are we doing on?
Reset to the plea docket.
Okay, can both of you come forward, please?
Here, go to their file here.
They're both on plea?
Yeah. They're both moving to the plea docket. You're on three docket.
Good afternoon, sirs.
Buenos días a ustedes, señores.
We're here on plea settings for both of your cases.
Estamos aquí con la cita de la corte para hacer declaración en la fecha indicada.
I understand that there is no resolution of your cases.
Él entiende que todavía no hay resolución del caso de ustedes. Your Honor, I should say that my client Carranza Galvez did sign a waiver of jury, and we do have a tentative agreement. The only reason we're not proceeding is because there's no Spanish interpreter available today.
Okay, so let's get that back at the next earliest setting. So whenever that next setting is, whether it be it tomorrow or our soonest opportunity. So, but given the gravity of those cases, let's do it as soon as we can.
So in this case, there is a resolution. En el caso de usted, tenemos una resolución, porque usted ha aceptado el acuerdo o la oferta del Estado. For Mr. Arnulfo Torres Padron, you're right. We don't have a resolution. We're very far apart. And we will continue to work on that and see if we can narrow our differences. En el caso de usted, no estamos cerca de llegar a un acuerdo, así que vamos a tratar de seguir negociando a ver si podemos acercarnos más a lo que el Estado está disponible a aceptar.
Okay, we're gonna set your case for a plea setting. That does not mean that you have to plead.
La corte, vamos a tener la próxima cita con la corte es para usted hacer su declaración de si eres culpable o no culpable, si eres juicio o no quiere juicio. Pero en ese tiempo no te tiene que declarar culpable si usted quiere o desea pelear el caso. ¿Okay?
Understand? ¿Entienden? Muy bien. Okay, that does not mean that you have to plead, but if there is no resolution, the next setting would be a trial setting.
Es decir, que la próxima cita con la corte no tiene que hacer declaración. Pero si vamos a ver, si usted decide pelear el caso, entonces la cita próxima a la otra, sí, vamos a ir a juicio en ese entonces. ¿Okay? En el caso que la próxima cita octubre no podemos ver, sí, si no podemos o si no resolvemos el caso en esa fecha, entonces vamos a recibir otra fecha, pero esa fecha va a ser para juicio.
Okay. Thank you. Thank you both. Thank you.
Yes.
Mr. Resendez, come on up, please.
Yes.
How are you doing, Mr. Resendez?
Hello.
Just one second. I need to ask the coordinator a quick question. Becky, on Resendez, I had that in August when we reset, we were resetting this one for a plea setting, but then on the document it says pretrial setting. Do you know what that's about?
Judge, I believe we were still working on some discovery issues.
Okay.
That we're still outstanding.
Okay, so what we're gonna do now is we're gonna reset this for a plea setting. That does not mean you have to plea, but if there is not a resolution at the next setting, your setting after that will be a trial setting. All right, so let's get that reset.
Today should have been a plea setting.
Should have been a plea?
Yes.
Okay, that's what I thought.
Error.
That's no problem. But can we please get the 15-day reset? And that will be a plea setting. Okay. So that's really what this was, but I'm gonna give you another chance since it's not indicated on here. Again, does not mean you have to plea, but if there's not a resolution, the next setting would be a trial setting. Understood? Yeah. Thank you very much. Anything else we need to take up? All right. Thank you very much. Thank you.
If I hear anything, I'll let you know. Because I'm not holding my breath. It's the bites. I just really like. Thank you.
Yeah. Mr. Evans?
Yes, Your Honor, I apologize, Mr. Target.
Juvenile hearing at Travis County, the kid that was in the middle of it.
Was that what?
At juvenile hearing at Travis County.
Okay.
So it took a couple hours of should have, I apologize.
No problem. Are you waiting to talk to her or to me? Okay.
My position is not changed. I do have an off docket.
Sure.
The opportunity.
What's this? Philip, are you working on William Love? Are you working on William Love?
I am.
What's status?
Will Hill is downstairs talking to his client about a new community.
Okay.
They've been on it for a while.
Let's run through the docket. Looks like page 1's done, Becky. Page 2, just Mr. Heights. Page 3, just Mr. Hill. Rashid Melton. What's our status there? State, have y'all spoken to Mr. Andera?
Double check.
Okay, let's go to page 5. Middleton, they're taken care of.
Looks like we have conveyed a plea offer, Judge.
He was.
Looks like we conveyed a plea offer.
Great. 6 were complete, 7 complete, 8 complete. So we're down to this one and Heights.
You have custody and 2 in custody.
Right, Love and Mr. Andera's client. Okay. Can I see the file on Middleton, please?
Yes, sir.
Dumpy, are you waiting on me on any more tunes we're gonna set for tomorrow? Are there any more that you have other than Audietti?
We got Flores page 2 and lettuce.
And who?
Let's go through them on two. Well, there.
Can I see the Valdez file? I think we already went through it. What's that? Yes, I gave you those. Ready? Or are you still talking? You're waiting?
Waiting on paperwork.
Okay. Oh, we're gonna take a plea? We're gonna do a plea? All right. What's our timeline? State, you doing it now?
They're getting ready right now.
All right. Let's get that moving.
It'll be reset for PSI, so.
Good. Valdez, Donkey.
Like you said, just give it a probation if you wanted.
Increase to 10,000.
If they do a bail certificate, it goes to probation, not to the file, and she wants to call the probation file and the future with those.
What is more convenient for everyone?
That's how it is done. We don't really want to show calls.
Okay.
It's just good to say for them, I'm not sure, because to their file and probation or how.
Okay, please sit on there. If you write on the, whenever you bring it up to us, the amount of 10,000 cash surety for the bond. How you doing, Mr. Craig? Nice to have you. How are you, Mr. Heights? You've been patient. Thank you.
We've been made an offer, we're going to ask him to move to the plea down.
Move it to the plea docket. Sir, that does not mean that you have to plea, but if there's not a resolution at the next setting, the one after that would be a trial setting. Understood? All right, thank you very much. Just wait a moment until you get your reset form.
And just a reminder, Judge, I think we're gonna run pretty long tomorrow. We've just got a lot, and we've got a lot of contested stuff, so.
I got to speak on Constitution Day at a high school in the afternoon. So I'll get here early and get as much as we done as we can early and shoot for timely.
Also, Molly and Philip will be out because they're quitters.
They're what?
They're actually, they're going to Galveston to the DNA training.
Scaramucci, so yeah.
They will not be here tomorrow. It will be me, and I will do my best to find some
Yeah, you
other
need
people
someone.
who can help come take notes and talk to defense attorneys. So.
Yeah.
But most of the contested stuff I think is mine, so.
All right. Yeah, let's try to get some, I can't be late for that thing.
What time is that?
I think it's 1:30, fifth period, which means I need to be out of here by 1 to get there in time. I mean, I think it's about 30 minutes, yeah. Take a break next morning.
Mr. Indira, what are we doing on yours?
Mr. Melvin is complete.
Okay.
Going down to paperwork signing out.
Are you back here in the county tomorrow?
I've been traveling on a case that's going to trial next week, so I can be here in the morning.
You can be here in the morning?
At 9 o'clock.
You can be here in the morning at 9?
No, I'm up in Travis. I've got a big case that's going next Monday.
Okay. Okay, so you have to go down and go through the paperwork with him?
Yes. And I'm also here at 1:30 with Judge Tibby. She's got some sort of meeting.
Tomorrow. Tomorrow?
No, today. I've got to come back at 1:30 here on the hall.
Okay. So then we'll do that plea. We'll do Mr. Melton's plea at 2 o'clock. Okay.
Thank you, Judge.
Thank you.
Do you know what Wednesday, Thursday, Sunday looks like? Have you looked at it yet?
I haven't looked at it yet.
Okay, we're still having tons of work done in the house. Orlando took off Monday, Tuesday, and I found somebody for Wednesday, Thursday here.
To be here?
To be here,
Okay.
but I wanna, I just hate to have somebody here. If it's like one case, it's not really gonna be on the.
Yeah, I haven't looked at it. Maybe we can go look at it.
That's fine, but I've got somebody.
Okay.
So we come back here at 2. Who are we waiting on now? We're just waiting on one case.
I thought it was. No, we got rid of it.
No, we're doing Middleton. Middleton plea.
Okay.
I think it's just that one.
Thanks.
Yeah. Oh, yeah, we got love. So what are we waiting on now?
Love, Middleton, Nelson.
Okay, so we're gonna do Middleton, and whatever's happening with love, we'll probably end up doing it too.
I think that there's a 50-50 shot that we do a plea today. I think there's a 50-50 shot.
Okay. Whatever you, so we can, unless Mr. Hale comes in before that, we'll we'll do the. What are we gonna do? We'll do Middleton.
Yeah.
And then plan to come back at 2.
Yeah, I'll tell Will, if he's still down there talking to, if we do reach a thing, we'll just come at like 2 as well.
Right. Well, we need to come at 2 because I need to see the defendant and tell him what the status is. Lydia causing trouble. She didn't hear me. Lydia causing trouble in here.
Oh, like.
No, we passed that probation. I'll be right back.
So here's the thing about interviews is that you have this goal of so any impact, any cause of their and like going down the ground or something, and so it's just like 9 times out of 10, like it's your hand can grab like a hand. Oh, I don't realize it.
Nothing will get you in more hot water with cops and like the crime and business and whatever. We saw some of them retaliation and stuff about apprehension and but like, if they're gonna be mad after that, there's nothing they can do, but you still have adequate apprehension. Regardless, not to make you happy, it's just justice, it's not a lot. Yeah. But at least like letting them know like, hey, we're okay, like I'm sorry this happened, but here's the issue with going forward, so this is. You're not wrong. Yeah.
You can be seated. All right, we're gonna do that one at 2 in 2 minutes.
That's it.
The plate.
Oh.
I put some retirement cake for Tim out there. Don't want any retirement cake for Tim. He hasn't retired yet.
We're trying to give him a hint.
I mean, I don't know.
Day by day basis, here's
The gentle suggestion.
That we all,
change from minute to minute.
I don't know when to keep up, so just, I'll be covered, you know? Just keep doing it.
Signatures, right?
It's all inclusive from now.
He's in custody, correct? Out of custody.
Okay, let's,
Oh, I have to have that filled out before I swear him. Yes, sir.
what is it?
Signed by both parties. The trial certification, it's just that the judge don't have, he doesn't have to necessarily sign it. This is fine.
Understood.
But I do.
Okay, well, y'all can do that after I take this plea. Mr. Middleton, can you come on up, please?
Just one more time.
Initial over here, initial with two check marks, yes. And then we'll file.
Okay, you swear in after I get done here? Yep, no problem, no problem. We ready?
Yes, Judge. Yes.
Court calls CR 234854F, the state of Texas versus Joseph Aloysius Middleton. Can counsel please make their announcements for the record?
Philip Gibbert for the state. John Evans on behalf of Mr. Middleton, Your Honor.
And are you the same Joseph Middleton who in CR 234854F is charged with possession of a controlled substance, cocaine, 1 to 4 grams?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I have here before me paperwork that indicates you would like to enter into a plea bargain agreement. This is on a 3rd-degree felony. State, what's the range of punishment on this case?
Not less than 2, not more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for this charge?
Yes, Your Honor.
I'm showing you paperwork labeled the written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there is a stipulation of evidence. I will use that, excuse me, that's on page 5, a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
And is this your signature on the final page?
It is, Your Honor.
So this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that this state brings against you. Do you understand those rights?
Yes, I do.
Understanding those rights, do you still wish to plea in this case?
Yes.
Are you a citizen of the United States?
I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's obligation to give you evidence under in accordance with Article 3914. Are you satisfied the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Middleton is competent to enter into this plea?
He's very competent, Your Honor.
Sir, the reason we talk about the evidence is because you have the right to know the evidence against you in a case. Did you discuss that evidence with your attorney?
I did, Your Honor.
And do you believe that he has provided you with effective assistance during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 3 years deferred adjudication. There will be a fine, restitution, an evaluation, and 200 hours of community service. Is that your understanding of the agreement?
It is, Your Honor.
Would you like to enter into that agreement now?
Yes.
To the charge of possession of a controlled substance, cocaine, 1 to 4 grams. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. What I'm going to do is order a PSI. Someone from probation will come and talk to you. Make sure you cooperate with them. And after they have completed a report for me, we'll come back and do your sentencing at a future date. Understood?
Understood.
All right. Thank you very much.
Very good. Thank you, Judge. Thank you for your patience.
Thank you.